Good afternoon, everyone, and welcome to the 2022 Con Law Moot. Congratulations for making it to the finals today. I'm going to now have our Chief Justice of the final round, Chief Justice Sossin, take over from here. Thank you.
Thank you, Jen, and to all the organizers of this moot. Kudos in advance of the final round, and of course to our participants, congratulations. I have the great privilege to preside with an all-star panel of judges, and I've asked each of them just to introduce themselves briefly before we begin with the appellants in the City of Toronto and Ontario Attorney General case this afternoon.
Hello, I'm Justice Benjamin Berger. I moonlight as a professor at Osgoode Hall Law School.
I'm Justice Faisal Baba. I too teach at Osgoode Hall Law School.
I'm Justice Jennifer Bilas. I'm a 3L student at Osgoode Hall.
I am Justice Cameron, and I used to be a law professor at Osgoode Hall Law School.
I'm Justice Glenn Chu, and I am a lawyer with the City of Toronto.
Justice Omar Ha-Redeye, and I am a father of 2 children, although I do have a law license.
I'm Justice Joshua Ng, and I'm an assistant crown attorney.
And I'm Justice Emily Wisnikowski. I'm a 2L student at Osgoode Hall Law School.
All right, welcome to all, and of course our appellants and respondents counsel know the rules and the slightly expanded time limits for this final round. So unless there are any other preliminary matters, let me invite appellants counsel to get us started.
Good afternoon, members of the court. My name is Nathan Reeves, and my colleague's name is Megan Rauser. We represent the appellant, the City of Toronto. The rights at issue in this case include some of our most fundamental democratic rights, and we urge the court to protect them. Before I begin, would the honorable justices like a brief summary of the facts?
No, I can speak on behalf of the panel. We've had a chance to review the whole record, and we're set to hear your arguments.
Thank you. We have 3 submissions to make before this court today. First, I will submit that Bayer is not the appropriate framework for the purposes of this Section 2B claim. Second, I will submit that there was a breach of Section 2B. Third, my co-counsel will submit that unwritten constitutional principles may invalidate legislation. The appellant requests that the Supreme Court of Osgoode Hall allow the appeal, overturn the lower court's decision, and restore Justice Bello-Baba's declaration that the timing of the Better Local Government Act unjustifiably infringes Section 2B of the Charter. Turning to my first submission, Bayer is not the appropriate framework for the purposes of this Section 2B claim. Bayer only applies to a limited number of defined circumstances that are unlike this case. In general, Bayer was designed to address under-inclusive statutory regimes. Its framework was developed in Dunmore and Ontario, which concerned under-inclusive labor regime. In Bayer, this framework was modified for an allegedly under-inclusive school board trustee election regime. Case law suggests Bayer applies to claims of under-inclusion, exclusion from statutory regime, and under-inclusive state action. In Greater Vancouver Transportation Authority, this test was confined to those unique circumstances. Justice Deschamps, as she then was, explained that Bayer, quote, summarize the criteria for identifying the limited circumstances in which Section 2B requires the government to extend an under-inclusive means of or platform for expression to a particular group or individual, paragraph 30. She also emphasized how Bayer shouldn't be taken out of context, since almost any freedom of expression case could be considered a positive rights claim. For example,
Counsel, if I can interrupt you, well, that may be right. Isn't the context here the very same context as Bear? That is to say, a would-be candidate that wishes to run in an election and that platform is taken away, and the issue is whether that platform is constitutionally required to be provided. Isn't that a description that fits Bear and in this case as well?
This case is quite distinguishable from Bear. What is being claimed is that the timing of provincial legislation interfered with political discourse during an ongoing election, which infringes Section 2B. It is the timing that's an issue, and the fact that it was an ongoing election. We're not requesting a particular platform. It's interference in the form of bad timing.
Counsel, if I could just ask, isn't it still the issue whether the government has a positive duty not to change city council, whether we're talking about timing or not? The issue is still whether there's a positive duty not to change city council.
Well, I think this illustrates a broader point, which is the differentiation between positive and negative claims is not helpful, but confusing and unnecessary. The Supreme Court of Canada has recognized that all rights and freedoms have both positive and negative dimensions. For example, freedom of expression requires the state make a space where one can express themselves, be it a public park. It also requires.
I'm sorry, Counsel. I just want to go back to some of the earlier questions. And you would agree, would you not, that you're not saying the city has some constitutional right to a 47 ward election, are you?
We are not contending that they have a constitutional right to that specific ward.
Okay, so if they don't, then what difference does it really make what the rules actually are if the entire framework isn't constitutionally mandated? Can't the province just change the rules because you don't have a right to the rules in the first place?
Although the province has a large amount of power in determining what municipalities can do, including how their elections are organized, they cannot trammel charter rights. The charter right being infringed is Section 2B, and it's infringed because political discourse was disrupted. It was rendered meaningless by the timing of this legislation.
Well, Counsel, it wasn't really rendered meaningless, though, was it? Because the candidates could have chosen to continue with the new reconstituted boundaries, and some of them chose not to, but they were still able to express themselves in that venue, were they not?
They were able to express themselves after this legislation came into force. But the issue is political discourse had already occurred in hundreds of days prior to the enactment of this legislation. It is this discourse that is rendered entirely meaningless. These candidates have completely different wards with completely different voters, and those voters have completely different issues. And these voters haven't even been able to express what their issues are, or they did previously, and now that expression had been rendered useless. This is where the infringement comes.
Can I ask you to clarify the connection between freedom of expression under 2B and participation in electoral politics? It seems like you're treating those two things as one and the same.
Well, it's the discourse which occurred and later became meaningless. Everyone is still able to participate in the election. No one is claiming that they were unable to enter or vote in this election, but it's what happened to the discourse prior to the change, which is an issue. It was rendered useless. There are countless examples.
They lost a strategic advantage, perhaps, but is the content of their expression and the effect of their expression truly rendered meaningless?
In some cases, this is explicitly true. Some candidates had produced and distributed campaign materials such as lawn signs or advertisements for abolished wards. They're now completely irrelevant. It is this.
Sorry. Finish.
Please go ahead.
So counsel, you said it's not a positive right that's at issue here. I'm wondering if you could move to your articulation of exactly what the negative interference with Section 2B is in this instance. Because if I'm not mistaken, the BLGA does nothing to restrict or prohibit or actively interfere with expressive activity. Is that right?
We believe this is a negative claim. The Supreme Court majority in Bayer stated that a claim is properly characterized as negative where the claimant seeks freedom from government legislation or action suppressing an expressive activity in which people would otherwise be free to engage. And it is the position of the appellant that the timing of the legislation suppressed the expressive activity of political discourse which occurred prior to the legislation's enactment. Without it, there would not have been the deletion of this important discussion.
Well, counsel, the legislation didn't sort of confine or suppress the expression. They may have altered the target or the goal, but they still allowed for the expression. And, I take your point about lawn signs, but the lawn signs were raising awareness about a candidate, not necessarily the structure of the word. And so where's the expression right that's being interfered with?
Under the second part of the Irwin test, it asks whether the government action in purpose or effect interfered with freedom of expression. In the electoral context, freedom of expression.
My question is the effect the election or is it the signs? Because the signs can still sit there. The signs can still be irrelevant as it relates to a platform, but it is still allowing for the expression to occur, is it not?
Expression was allowed to occur for those 69 days after the nomination period. The problem is that many candidates had been campaigning for over a year by this time. And that discourse, reciprocal deliberation between voter and candidate, was entirely rendered meaningless. And this is the expression that was suppressed. The effect of the legislation was the suppression of political discourse. And that satisfies the second part of the Irwin-Toy test. The first,
how is could you just clarify, how is the negation of the significance of past speech the same as silencing speech?
It has the effect because it required candidates to reach new voters with new priorities. The priorities they had previously campaigned on and created a forum about are entirely, those are as good as nothing at this point. So the problem is that a huge amount of time, a huge amount of democratic discourse was.
Counsel, you're saying a huge amount, but could it mean any amount? How do we know what a huge amount is? How do we know what a little amount is in this context?
It's quite readily quantifiable since some candidates had been campaigning for hundreds of days. To say that 69 days is equivalent, that it makes up for that loss of political discourse, that's not mathematically correct. It doesn't. That is where we draw the line. It is disproportionate.
It almost sounds, counsel, as if you're trying to constitutionalize wasted expression. And my concern there is that you can think of a myriad examples. So let's say a corporation that is advertising, and then the legislature passes some laws regulating that industry, and they would be able to make a claim about wasted expression on the same basis.
Well, the alternative is that we adopt the Bayer test, and this test comes with its own set of drawbacks. The consequences of a more stringent test mean that some activity that would otherwise constitute a breach under Irwin would not be found to infringe rights. If you find an infringement under Irwin, that's not the end of the discussion. There's not some sort of automatic process. There are other stages. So when we talk about a threat, maybe you're saying some sort of floodgates argument. Well, the flip side to that is suppression of democracy, because if we adopt a more stringent test, some breaches that would be found, or some activities that would be found to breach Section 2B would no longer be found to breach in the first place. I believe you're muted.
Can you differentiate other political expression from other forms of expression under the Irwin-Toy model that you're proposing here? I'll try to help you. Is there a difference because of the nature of the expression that we're dealing with here, Counsel?
Absolutely, and it's the political discourse, the democratic nature, which makes it so important. It is so vital to protect. This is different from just general other expression. Democracy underpins our entire society, so it is justified to protect it.
Counsel, I still don't understand. Like, you were talking about times, length of time, and you're saying that one is significantly more than the other. Are you saying that had there been more than 69 days left to reorient everyone's campaign, if they gave the same amount of time before the act came into force, and that would be okay then, because then we're equal, or maybe even more time afterwards? Would that satisfy the problem for you?
Pointing at definite numbers might be outside the purview of this case, but it would to some extent remedy the problem. The problem is that there were hundreds of days worth of campaigning and political discourse, and you cannot make up for that time in 69 days. So perhaps if it was equivalent, that would logically seem like that freedom of expression which was infringed could be made up by new discourse. It is the timing of the legislation which caused this freedom of expression infringement. Bayer is not the appropriate framework for this Section 2B claim. Irwin-Toy is. It readily demonstrates that Section 2B, freedom of expression, was infringed by the timing of this provincial legislation. Barring any further questions, I will now conclude so as to allow my co-counsel to complete submissions on behalf of the appellant.
Thank you very much, counsel. And if your co-counsel is ready, we're now prepared to hear from her.
Good afternoon, Justices and our friends, Counsel for the Respondent. I will turn to our third submission, that unwritten constitutional principles are substantive legal rules in their own right and can therefore be used to invalidate legislation. Turning now to my submission. Canada's Constitution has embraced unwritten sources such as the norms, acts, and conventions of the Presidential Constitution of the United Kingdom. While constitutional text may emanate from underlying principles, this doesn't mean the principles themselves are relegated to mere context. To quote Justice Abella at paragraph 167, these unwritten constitutional principles are the vital, unstated assumptions and principles held to be the lifeblood of the Constitution, and they must not be so.
Counsel, you note this broad nature and perhaps amorphous nature of these unwritten constitutional principles, but I struggle here if we can use them to invalidate legislation and they're kind of difficult to understand. Maybe there are different interpretations and they would be applied unequally in different scenarios. So how do you account for the fact that everyone is equal before the law and that these should be applied in a similar way? How do you account for that sort of discrepancy then?
Well, I think the first way to account for that would be, first of all, to note that we are submitting that these legislative principles would only be used in very rare scenarios. So by limiting that applicability, there would only be rare cases where they would apply. So that makes the
sorry, what kind of cases?
Less of a problem.
What kind of rare cases are you thinking of where it would apply?
We would submit that the kind of cases where they would apply would be those where it is only the most extreme circumstances where the Constitution might not cover it. And as we saw with the secession reference, although there are other remedies to address issues that go against the Constitution, there's always going to be the odd case that comes up where there might be a gap. And since unwritten constitutional principles aren't an issue that needs to be decided in this case, as my colleague has demonstrated that there was an infringement, We submit that the court shouldn't make a decision on this, as they don't have to do this in order to allow the 2B submission.
Well, counsel, I think we still have to consider your argument in light of the fact that your colleague's argument may be unsuccessful. And so I'm having some difficulties understanding where I might be able to find or identify or look up any vital, unstated assumptions if they're not written down. So that likely, as was alluded to by my fellow justice, there might be some disagreements about what those assumptions might be.
Certainly, Your Honor. One place to start would be the Quebec secession reference, for example, where the court listed the unwritten constitutional principles. And so in the Quebec secession reference, they also held, a unanimous court mentioned, that the underlying constitutional principles may in certain circumstances give rise to substantive legal obligations, which constitute substantive limitations upon government action.
But counsel, that's the court. That's the court identifying for itself what some of these vital unstated assumptions might be, right? And so is that perhaps the court giving itself undue power to identify any principles that it wants to, whenever it wants to, in order to override written constitutional principles?
Your Honor, first of all, we would like to note that these unwritten constitutional principles and the text, they're co-equals. So the textual provisions are drawn from these underlying unwritten principles. And to address the issue of judicial review, and perhaps I think as you're suggesting that judges may potentially overstep here, we would like to note that similarly to how Parliament entrusted the interpretation of the charter rights to the court, it's not undemocratic for judges to apply unwritten constitutional principles to ensure our law evolves to reflect the reality. This is a very important purpose. And although the underlying principles are not explicitly made part of the Constitution by written provisions, the oblique reference in the preamble to the Constitution Act makes it impossible to conceive of our constitutional structure without them.
Could I just ask I'm sorry,
go ahead.
Justice.
Go ahead.
Cool. Ms. Rauser, I wonder if you could help me with something, maybe now or maybe later, but you're urging on us the adoption of unwritten constitutional principles with substantive legal effect, and not just substantive legal effect, but substantive legal effect in the form of invalidity of legislation. Now, I wonder if you could address, if we were to adopt your submissions or accept them, how would this interact with amendment and amendability? So to accept unwritten constitutional principles, where does that fit into our amendment formula? Does that mean there's unwritten amendment possibilities as well? So part of the virtue of the written text is we have an amendment procedure. And so I really need to understand structurally how your submissions would fit with constitutional change.
Thank you for your question, Your Honor. We would not submit that this would allow for unwritten constitutional amendments. We submit that the unwritten constitutional principles are capable of invalidating legislation because these principles they work as co-equals with the text. So that's how they draw their authority, because they work together with the text.
But how would you amend an unwritten constitutional principle? How would one do that?
That is an excellent question, Your Honor. And we would urge the court to wait until we have a case where the facts are before the court to address that matter.
Well, in the facts we have before us, of course, there are competing narratives about what would support democracy. This isn't a matter of a government intending to legislate so as to subvert democracy. The government's clear stated objectives are to enhance democracy in the legislature's vision of that. So in the other cases where there has been some reference to these unwritten constitutional principles, there's a framework, a methodology, there's factors, there's balancing. I'm thinking here of judicial independence and others. So what do you propose other than just an amorphous, I'll know it when I see it, concern with democracy that would be applicable here and that in fact is infringed in your submission by this legislation?
Your Honor, we think a propositive interpretation would work. So for example, the court could combine the unwritten principles of democracy with the textual provisions, such as Section 3 of the Charter or 2B, and other unwritten expressions, such as effective representation. And so the unwritten principle of democracy, it remains a substantive legal rule, so it does have that authority there, but there is textual provisions that could be drawn in as well to help provide the structure that I think you're seeking.
So
Counsel,
counsel, sorry, Justice Cameron, go ahead.
I just wanted to explore a bit the proposition that the unwritten constitutional principles are co-equal to the provisions of the text. And I'm unclear from your submissions whether you consider the unwritten constitutional principles to be kind of helpers to the text, or you contemplate a situation in which the unwritten constitutional principles would have some sort of would prevail over the provisions of the text, and what that relationship is that you're envisioning here.
We certainly would not want the unwritten constitutional principles to prevail over the text. Ideally, they would not be competing. They would work together as they do share some similar goals. And we would also note that they should not be just confined to being an interpretive aid. The preamble is not only a key to construing the express provisions, it invites the use of them to fill out gaps in the express terms of the constitutional scheme. And I think one case that really demonstrates how well they work together is the provincial judges reference, where the text and the underlying constitutional principles work together in that decision. And another case we could also look to would be the Trial Lawyers Association of British Columbia and British Columbia, where the lower court struck down regulation imposing hearing fees that were found to deny people access to the courts, based in part on the unwritten constitutional principle of the rule of law.
So I just want to follow up on the idea of what co-equals mean, because Justice Cameron, I had the same, you read my mind, Justice Cameron. Are you saying it's possible that the written text would trump the unwritten constitutional principle where it's explicitly opposite of what an unconstitutional principle might say? Is that your position?
No, Your Honor. Since they're co-equals, we don't think either of them should be able to trump the other.
Okay, so then in your framework, then how do you fit Section 33 and Section 1 of the Charter?
We do concede that this is an issue that may arise. However, we submit that we should wait till this issue arises before the court so that we have the facts to fully evaluate this matter. And we could also, in the meantime, turn to other parliamentary systems. Notwithstanding their different constitutional arrangements, they also have recognized that unwritten constitutional principles have full legal force and can serve as substantive limitations on all branches of government. So for example, if we look at Australia or the United Kingdom, we could perhaps turn to there for guidance in the meantime until the facts arise before this court.
Okay, what if we disagree with you that unconstitutional principles are co-equals to the text, but that we don't necessarily agree with your friends who are presumably going to tell us that they're meaningless? What else could we do?
Well, Your Honor, even to take my friend's argument, the majority mentioned that the unwritten constitutional principles can be used to develop structural doctrines that are unstated in the Constitution, but are necessary to the coherence of and flowing by implication from its architecture. And so those are meant to fill gaps on which the text itself is silent. And this is precisely the case at bar. The framers left a gap in the Constitution. They were trying to patriate the Constitution during a time where the unity of the Federation itself was extremely precarious, and the focus was on creating a federal state. The preamble could be considered a broad catch-all provision in the midst of this hectic context to create space for constitutional evolution.
I wanted to just pause on that last point you made and the importance of Canada's federal state as another unwritten constitutional principle alongside democracy. And don't they work together? That is to say, it's democracy in the provincial or federal electoral spheres that has some constitutional traction. But elections to school boards, to municipalities, to any number of other creatures of statute, be they provincial or federal, aren't those all administrative tribunals of one kind or another? And don't they occupy a different space than our provincial and territorial legislatures and federal parliament?
Your Honor, the school board elections you mentioned certainly do have a different character than provincial, federal, or municipal elections. Municipalities are a cornerstone of Canadian democracy that have been a part of political life in Canada since before Confederation. They also play a critical role in ensuring the local needs of constituents are met. And the lower court in Godbout noted the highly analogous nature of municipal councils and provincial legislatures, including features that are at the heart of our democracy, such as democratic
Sorry,
elections.
Counsel, to interrupt you, but are you saying that we should be kind of reading in some sort of municipal government into Section 3? That there's
No,
some
Your
sort
Honor,
of
we would-
inherent right to a democratic election at the municipal level? Is that what you're saying?
Sorry, Your Honor. No, that I was not meaning to give that perception. We are not submitting that they should be added into Section 3. We merely think that the court should stick with the current jurisprudence where they've been very responsive to the evolving nature of municipalities. And so our primary focus with our submissions is ensuring that the candidates and the voters have their freedom of expression respected. And as the scope of municipal responsibility evolves, the court has been very responsive, which you can see in United Taxi Drivers Fellowship of Southern Alberta and Calgary, where Justice Bastarash observed that the municipal election has produced a shift in the proper approach to interpretation of statutes empowering municipalities. And the fact that municipalities are creatures of statutes is not sufficient justification to trample the democratic rights of voters. As Justice McLaughlin stated in Shell Canada Products Limited in Vancouver, courts must accord proper respect to these rights and responsibilities to ensure the continued healthy functioning of democracy at the municipal level.
Ms. Rauser, if I can ask just one question on your gap argument. So how do we distinguish a gap in the written text from simply a failure to afford a right? So we could say, in fact, that the Charter says a great deal about democratic rights. They have Section 3, Assembly in 2, Expression in 2, a variety of other rights. It's not a gap, it's that no rights were afforded. So how do we know that we're dealing with a gap rather than an intentional absence of the affording of a right?
Well, Your Honor, I think as I mentioned, the historical context of when these rights came in is extremely important. The federal government and the province were working very hard to, oh, sorry, I noticed that my time is up. Do you mind if I answer your question?
Please finish the question, or the answer I should say to the question, yes.
Okay, thank you. So in the secession reference, they cite the provincial judge's remuneration reference, and they note that the history here is very important. At that time, the focus was on the federal and the provincial governments because municipalities weren't that big during that time. The society was much simpler and their role has evolved. And so we note that this is a gap because they simply didn't have the same responsibility. And so we think the court should maintain unwritten constitutional principles so we have the living tree approach to adapt to this new reality.
All right. Thank you very much to both our appellant counsel, and I'll come back to you should you wish to take advantage of the optional 1 minute reply. But now I want to turn to the respondents, and I'll go out on a limb and suggest they may have a different perspective on the matters that we've heard so far. So if our first responding counsel is ready to unmute, we're now ready to hear from you.
Your Honor. Good afternoon, Honorable Justices. My name is Dalraj Gill, and with my co-counsel, Tripat Sandhu, we represent the respondent, the province of Ontario. The Better Local Government Act, hereon known as the Act, which reduced the number of wards from 47 to 25 in the City of Toronto, is in fact constitutional. We are putting forward 3 submissions in support of this position. Firstly, there is no violation of Section 2B or Section 3 of the Charter. Secondly, contrary to my friend's claims, the buyer framework was correctly applied by the Supreme Court of Canada. And lastly, as my co-counsel will further discuss, unwritten constitutional principles cannot be used to invalidate legislation. We submit that the freedom of expression found in Section 2B is not engaged by the appellant's claim. As found in the Supreme Court's Irwin-Toy decision at paragraph 3, activity that does not convey meaning or does so through a violent form of expression is not protected under this right. Our friends claim that reducing the number of wards on the day nominations closed for the municipal election is a violation. However, the issue at hand does not involve any interference with any such expression. As found on paragraph 73 of the Bear and Alberta decision, Justice Rothstein affirmed that there must be a communicative purpose for an act to qualify as protected expression.
So,
In this
Counsel,
case-
I have some difficulty with relying without any reservations on Bear, especially because Bear itself was extensively based on the framework in Dunmore. And do you really hold that? Do you think that Dunmore and Bear are both good law in their entirety? Is that the proposition that you're putting before the court?
We do not believe they are good law in their entirety, but we say this because the Bear framework was specified and shortened in the Supreme Court decision. It was simplified to include 2 points. One, those cases in which a positive rights claim is being made. And secondly, if that claim is being made to gain access to a particular statutory regulatory platform for expression. And we submit that that is exactly what the city is asking for. And the reason why is because there is no Section 2 violation. We say this because in this case, being able to communicate, there was a communicative purpose to the acts at hand. Being able to communicate policy and campaign ideas would be considered communicative forms of expression that conveyed meaning. But these forms of communicative expression are not affected by the act. All this is to say, candidates and their supporters had 69 days before the election.
Sorry, Counsel. I just want to, there's a lot of what you packed in, what you just said, but I want to focus on the last thing that you're talking about. And you're saying there's no difference, I guess, at the constitutional level, the way we're understanding this, between political expression in the abstract, just talking about political views or policy, and expression that is occurring in the context of an election, where people are out there trying to actually secure votes, and voters are out there actually to try and figure out whom they should vote for. You're saying those types of expression are all identical in the Section 2B analysis, is that right?
I would disagree with that statement. We are not trying to establish that those expressions are equal or similar. However, we believe there is a distinction between communicating one's political leanings, opinions in preparation for an election, and materials losing their efficacy as a result of the platform being taken away. The materials at hand, such as lawn signs or we call the signs that go on the doors, did not lose their communicative substance. That communication, those messages, could still be expressed through various different avenues. The avenues were diverted, but the communication and that expression.
But sorry, let me just follow up on what you're saying. So the lawn signs stay there, and you're saying they still say what they say. No one said they had to be taken down or anything. And you're saying the fact that all the wards are reshuffled, and there's a sign there that says, please vote for me for Ward 39, which doesn't exist anymore, is still okay, and that nobody's previous expression has been interfered with simply because the lawn sign can still stay on the lawn?
We believe that there is an impact on efficacy, but the material itself, the communicative messages, could still in fact be expressed. And that lawn sign, if candidates did choose.
So, Counsel, could I just ask you the question, which is this: how is it possible to deny that the enactment of the BLGA did not substantially disrupt an active, ongoing electoral process? How is it possible to deny that the legislation interfered with the election, principally by completely restructuring city council and all the electoral boundaries? Because what we're concerned with here is the government's action and the government's interference with an ongoing election. Is that not the case?
It is, and we would like to submit that that brings up another important distinction, which is between the freedom of expression and Section 3 rights to vote. And the Section 3 rights of the Charter to vote are explicitly extended to provincial and federal elections. municipalities were deliberately omitted as found in paragraph 65 of the Imperial Tobacco Decision. And the reason why they were deliberately omitted was because in section 92(8) of the Constitution Act, municipal institutions are subsumed under provincial powers.
Counsel, but I think Justice Cameron's question was about section 2B and whether or not you could really say that there has been no substantial interference with what was going on before the BLGA came into effect.
Again, I would like to disagree. We submit that we do disagree with this position. And the reason why is because the integrity of the election that did occur under this new structure is not contested. And furthermore, we submit that it would not be possible to engage in a hard-fought election through the use of town halls, through an active election, if it were not for freedom of interference.
Sorry, Counsel, again, isn't it being contested? I mean, isn't that what your friends are doing?
We
They're
submit
seeking a
that
declaration that it was unconstitutional.
the declaration is connected to the timing of the legislation rather than the election itself. Were the election being contested, we submit that it would be a separate constitutional issue. However, the matter at hand concerning freedom of expression, as our friends mentioned, is strictly limited to the timing of the act. The timing is subsumed under those 92(8) powers. So we find that the province's actions in enacting such legislation were not constitutional. And because the Section 3 rights are not extended to municipal elections, it was well within their power to do so. And it does not raise any charter issues.
But Counsel, let me ask you to focus on timing for a moment, because it seems that is what much of the Section 2B arguments come down to. And there seemed to be a disagreement between the majority and dissent in the court below as to whether it was 1 month or 2 months. But and of course, the majority referred to 2 days as of course, a scenario where all would agree that the disruptions could cross that line. But where is the magic line of timing? And should we have reference to how many days of campaigning had preceded the legislative change, or how many days are left, or both, or neither? What's your submission on behalf of your client for that question?
There is no magic line. And because the constitutional protections are not extended to municipal elections, we find that those issues are resolved at the ballot box for the provincial elections, that the timing of the provincial elections would matter more and require a more extensive constitutional analysis. But because municipal elections are subsumed by the province, they were well within their power to do it 69 days before.
Counsel, are you saying that municipal elections are less important than provincial elections? Is that what I'm getting at here? That these are not equal things, or not equal expressions of, your political will?
We submit that they are equal expressions of political will. However, we must also consider the written provisions in the Constitution. And as my co-counsel will speak to about the unwritten constitutional principles, the written provisions are fairly clear. And it's that municipalities were deliberately omitted from this. If you look back, municipalities have predated the Magna Carta. The framers of our Constitution were aware of their existence, but intentionally omitted them from the Section 3 protections. And during the rigid constitutional negotiations, it was settled upon that they would fall under provincial mandates, under provincial powers. And for that reason, we submit that the province's actions were not constitutional. Were constitutional, and for this reason do not bring up any further legal issues.
Counsel, how is Section 3 an answer to the Section 2?
Well, let's have Justice Cameron go first, then Justice Baba, then Justice Berger.
Just a one-line question, which is, how is Section 3 an answer to the Section 2B claim?
The reason why is because the Section 2B claim concerning expression is not engaged in this case. The reason why is because they were allowed to express their political opinions. Our friends claim that the timing limited their ability to express. However, there were many alternate avenues to express these political leanings. Section 3 is engaged in terms of invalidating the Constitution because we want to afford those same protections of timing that stem from federal and provincial elections into municipal elections. However, it seems as though our friends have combined the two, the Section 2B and 3, and made a claim where the election provisions are now being interfered with through an expression claim, We're trying to create that distinction and assert that in either case, section 2B or 3, there is no constitutional issue.
And Justice Baba, did you want to follow up on that?
Okay, yeah, so maybe I'm stating the obvious, but just to understand your argument, you're saying section 2 permits expression, but that expression, there is no presumption that that expression be given any weight, significance, or strategic value in the context of an actual election, unless you can hook it on to section 3. And you say section 3, the section 3 hook doesn't exist for municipal elections. So therefore, municipal elections are essentially outside the scope. So you're not saying that it's constitutional, you're saying that it's beyond the scope of constitutional review. Is that accurate?
To a certain extent, yes. However, I would disagree in terms of the first claim. We believe that expression is very important and should be protected, including in the context of a municipal election. However, we submit that the expression was not limited, was not interfered with, because there still remained alternative platforms to express the political leanings and opinions that had been campaigned during the year prior. And this is important. Yes.
Oh, actually, Justice Berg, I don't want to interrupt, but
please go ahead, Justice Chu. I'm on a different point.
Okay. Well, I'm still struggling to understand how saying, you say that there's no interference with expression when everything else has changed, how that really matches reality. I mean, sure, somebody can still continue to say, vote for me in this particular board, but it doesn't exist and the person doesn't run there anymore. How can you say there is actually no impact?
We submit that there is impact, but the impact is on efficacy rather than the content of the communication. One can choose to resubmit their nomination form. There were forms that were made available for those candidates according to the reconfiguration of the wards. That opportunity was not exhausted by some. That does not mean that the government was then interfering with their opportunity to do so.
Let's let Justice Berger make sure to have his point.
My question, Counsel, is actually in line with Justice Chu's to some extent, which is the extent to which you're asking us to depart from the idea that Section 2 expression jurisprudence is supposed to be highly contextual. And your argument seems only to work if we think about specific words or specific signs or options to begin a new conversation. But it seems extremely sort of formal to me and not contextual to say that all of the conversation, all of the debate that took place prior wasn't part of the giving, exchanging of reasons, the forming of political positions. And in particular, I'm interested in, as part of that, whether you view and whether in your submission, the approach we should take to the candidate and the voter differ at all under the Section 2 analysis. Are they just the same in their Section 2 interests? You seem to be bundling them totally together. Are they to be distinguished in how we think about their Section 2 interests?
They are to be distinguished, and I believe we submit that as a very important consideration to make. When speaking about the voters' right to expression, we'd also like to submit that that can be extended and is protected under the provincial elections. At the end of the day, 92.8 provides the provinces this power over municipal institutions and their elections. And if they have exercised it so, and the voters themselves are not happy with this decision, they can take this discontent to the ballot box. At that point in time, their expression is heard. It's still being heard now within the municipal elections that occurred. However, they have alternate opportunities. They have further opportunities that are constitutional.
But on this point, Counsel, if I might just follow up, I find a bit perplexing your view of Section 92.8. So what you're saying is any voting-based expression or political expression interests at a municipal level are exhausted by the fact that Section 92.8 gives that power to the provinces. But that's what the Charter does. It limits the scope of provincial and federal legislative authority. And so I just don't follow the structure of that argument. I mean, the federal government has jurisdiction over criminal law, but there are a bunch of rights that say what can't be done. So the argument here is that here expression is being interfered with in the exercise of 92(8) jurisdiction.
And maybe just take a brief moment to conclude. I know your time is up, but I do want to ensure there's an opportunity to answer that question.
Thank you, Your Honor. Sorry, Justice Berger, if you could just repeat the last part of your question for clarification.
Well, you seem to be suggesting that because Section 92(8) gives authority over municipal institutions to the province, that somehow that means that any expression right is exhausted and that the province doesn't have to comply with freedom of expression. But I mean, that's the structure of the Charter's interaction with federalism. It's just a perplexing kind of stance. I don't quite understand it, perhaps.
I would agree with that statement. When we say the provinces have power over municipalities, we do submit that it is unfettered and absolute, as according to paragraph 65 of the Imperial Tobacco Decision. However, at the same time, any action taken by the legislation is subject to charter scrutiny, and we submit that there is no charter interference to begin with regarding Section 2B or Section 3.
Thank you very much for completing your answer. And if your co-counsel is ready, we're now ready to turn to the final submissions on behalf of the respondent.
Good afternoon, Justices. My name is Tripat Sandhu, and I will be building off my co-counsel's submission to address the third and final issue of unwritten constitutional principles, specifically democracy. My friends argue that the change in word structure violated the unwritten constitutional principle of democracy by denying voters effective representation and disrupting the election process. We submit that the unwritten constitutional principle of democracy alone cannot invalidate legislation without the support of written constitutional provisions. The Supreme Court of Canada's decision in this case steered correctly in determining this. First, we need to look at the purpose of unwritten constitutional principles. These principles have an interpretive and gap-filling role to written constitutional text. The Supreme Court of Canada, in reference regarding secession of Quebec, describes the full legal force unwritten principles possess are to be used as interpretive tools for constitutional provisions, as outlined in paragraph 54. Second, principles fill gaps and address important questions on which the constitutional text is silent, while remaining coherent to the Constitution's architecture. We submit to push back on our friend's argument and explain that unwritten constitutional principles are not co-equals to text. The text of the Constitution is paramount. Principles may help interpret text or fill gaps, though it cannot supplant the text, as we have seen in jurisprudence. For example, in the recent Trial Lawyers Association of BC case, it concluded that the BC hearing fee schemes were inconsistent with Section 96 of the Constitution Act and the rule of law. We find that this is a distinguishing case, given that this relies upon not just the rule of law, but also Section 96 of the Constitution Act and policy purpose relating to access to justice to support its conclusion. So,
Counsel, you mentioned the secession reference and you cited paragraph 54, but in paragraph 56, it expounds a little bit further about how these principles can be used to develop structural doctrines unstated in the written constitution, in particular in filling gaps and addressing important questions on which the text of the Constitution is silent. And I think what we're hearing from the submissions here today is that there's a potential gap between Section 92 of the Constitution Act and the province's power as it relates to municipalities, and how Section 2B of the Charter interacts with that. And so is there a role of the unwritten Constitution in filling that gap?
Here we find there is no gap to be filled because of the written provisions of the Constitution Act, such as Section 92, subsection 8, assigning provinces exclusive legislation authority regarding municipalities. So
okay, but Counsel, I think this point has been made as well, but in 1982, the provinces and the federal government came together and chose to amend our Constitution that would subject their authority, including the Constitution Act in 1867 and Section 92 and all the powers there, subject to the Charter. And so isn't those Section 2B rights still an important consideration as to how the province exercises its power?
So Section 2, I'm trying to understand your question. Is it possible to rephrase it?
The Charter still overrides, let's say, legislative power. I don't think anybody disputes that. And the Charter or the Constitution, as it's understood in 1982 thereafter, is different than the way it would have been understood in 1867. And so in trying to understand in this modern era, this post-Charter era, as to how expression rights should be given full force and effect in municipal elections, should not the unwritten Constitution be used to fill any such gaps?
So in relation to Section 2B, it protects expression which can be exercised through the ballot box. But the ballot box it protects is provincial, and through that system, the province decides what the ballot box for municipalities will look like. So that can only be applied if there is a 2B violation. So moving forward, the principles of gap filling and interpreting text do not extend to invalidating the Better Local Government Act. And I'll outline a couple of reasons why this is the case. First, by using democracy to invalidate legislation is an attempt to trespass into legislative authority to amend the Constitution. This raises the concern about the legitimacy of judicial review and distorting the separation of powers, as outlined in Imperial Tobacco paragraphs 53 to 54. So if we take a look at the Constitution Act, sections 91 and 92.
Sorry, Counsel, since you mentioned Imperial Tobacco, didn't Imperial Tobacco also analyze the case with respect to judicial independence, which everyone, I believe, understands is an unwritten constitutional principle? So there was no, as far as I understand that case, there was no suggestion by the court that, well, we can't really do this. We're going to analyze whether or not that particular act violates judicial independence, but we can't really do that because it's an unwritten constitutional principle that doesn't actually have that kind of power. Do you understand what I'm saying?
I will attempt to answer. So
it seemed to accept that judicial independence could have potentially struck down that act. It just did not, in their opinion, meet that bar, but they didn't say you couldn't do it because they went through the analysis, it seems to me.
We find that in Imperial Tobacco as well, Justice Major stated that legislation that some might view as unjust or unfair properly lies not in underlying principles of our Constitution, but in its text and the ballot box. And as well, the rule of law they stated in there was not an invitation to trivialize or supplant the Constitution's written terms. So I wanted to also state that unwritten constitutional principles are highly abstract, and unlike charter rights, in which charter rights are highly debated and refined through rigorousness, unwritten constitutional principles do not promote legal certainty and predictability as the text of the Constitution does, as stated by the secession reference in paragraph 53. Further,
Counsel, isn't that true until it isn't? In other words, judicial independence is a very abstract, amorphous idea, but then through interpretation, courts have given it refinement and a methodology and a framework that's now become well accepted. And of course, some would look to section 11 of the charter as well as the unwritten principle as roots of judicial independence. But be that as it may, wouldn't democracy unfold in the same way if it's explored and examined and given flesh on the bones through that interpretation? So these unwritten principles aren't static, they're not fixed in time. Wouldn't that be a potential route, just as it has been with other principles?
Was it possible to once again just rephrase your final question?
So in other words, you mentioned that a democracy is abstract as an unwritten constitutional principle, and accepting that, isn't it abstract until courts give it further meaning and further refinement and add flesh to the bones as they have in the context of other principles like judicial independence?
Yeah, so we submit that these unwritten constitutional principles should be in combination with written provisions, in combination with possible policy considerations. So they just by themselves cannot be used to invalidate legislation. They're given meaning with tandem of written text.
Counsel, my follow-up question here is whether or not your submission, whether you're arguing that this court should revisit the proposition below that honor of the crown is an unwritten constitutional principle that can invalidate legislation. Are you saying honor of the crown also should not be used to invalidate legislation? And if not, if you agree with the majority below that it can be used to invalidate legislation, can you help me with why? Why is honor of the crown distinct from these other amorphous, interpretable concepts? Why would we put the boundary there rather than honor the crown plus democracy, perhaps?
So in relation to honor of the crown, I do not have the facts before me to answer that question. But I can submit that if a court were to rely on unwritten constitutional principles to invalidate legislation, there's many consequences to it. So one of the consequences also is how it has that impact of Section 33 and Section 1 of the Charter, as the court had asked our friends to speak more about. For instance, Section 33 only lets the government to invoke a notwithstanding clause to override Sections 2, 7 to 15 of the Charter. And if we were to use democracy to invalidate legislation, that means that a province can do nothing about invoking Section 33 to unwritten constitutional principles in the future. And it's important to note that Section 33 was an immense bargain in the formation of the Charter. By having unwritten principles invalidate legislation, this diminishes provincial power when creating legislation, since there's the potential of unwritten constitutional principles to strike it down. And further,
Counsel, Section 33, as you pointed out, doesn't actually apply to certain provisions of the Charter that are labeled democratic rights. So in a way, it's not really contrary to what's written, wouldn't you say? At least with respect to democracy.
I would submit that that's in relation to Sections 2 and 7 to 15 that it would only apply to. So a careful review of further jurisprudence will support the conclusion that unwritten constitutional principles cannot invalidate legislation. For example, the reference regarding remuneration of judges in PEI decided whether the principle of judicial independence restricted the extent to which government could reduce judge salaries. And in that ruling, we submit that the court interpreted judicial independence in combination with Section 11, subsection D of the Charter and Sections 96 to 100 of the Constitution Act. And Chief Justice Lemaire in that case explicitly emphasizes the merely interpretive role of the principle of judicial independence in working with Sections 96 to 100.
Your friends have made an argument that relies both on a textual right and an unwritten principle. So why should we not use the unwritten principle to better understand and illustrate your friend's Section 2 argument?
Yeah, so unwritten constitutional principles are so abstract, so amorphous. So we can use it potentially to in tandem with written text, but when it comes to Section 2B, once again, it protects expression, which can be exercised through the ballot box. But that ballot box is connected to provincial powers.
And Counsel, do you see that understanding of the ballot box evolving? In other words, as municipal democracy becomes more and more important, as Canada becomes a much more urban community and as the powers devolve down to cities and towns become so important in people's lives, does that balance start to shift, at least within the context of an unwritten principle of democracy, or do you see it as static and fixed for all time?
We submit that it can be static, but it is also up to like the constituents to vote in the government they want to see running the province. Or
Counsel, how can it remain static in the context of the fact that Canada's constitution is seen as a living tree that can change with the context and the way that society evolves?
Is it possible to rephrase that question?
Sure. So the idea that the Canadian Constitution is seen as a living tree and that it can be interpreted in ways to adapt to the way that society is evolving. You said that the way that we can see this right is static, you had mentioned. So how can we square those two things?
Well, we do have jurisprudence that still supports that it may not be static, but the use of written provisions is still supreme. And this is because we use unwritten constitutional principles or policy as support, but it's not the final word. Given the time, I would just like to conclude and explain that by having—
Actually, I'm sorry to do this, but I just wanted to ask you a question that I don't really understand. You say that the answer to be or unwritten constitutional principles with respect to this issue is at the ballot box at the provincial level. And this goes to I guess some of the earlier questions from the panel are you saying that if the province, in exercising its powers under section 92 sub 8, said, you know what, we're going to have an election, a municipal election, but only men can vote, there's nothing anybody can do until the next provincial election?
We submit that would raise constitutional concerns, but we have none here. The province can do something like this legislatively, but we find that there definitely be policy concerns that would be raised against that. So I would just like to conclude that as the respondents for the province of Ontario, we presented to you why this appeal should be dismissed, and my colleague outlined how section 2B, the freedom of expression, fails. And then we presented to you the purpose of unwritten constitutional principles and why the principle of democracy alone should not be able to invalidate legislation. Thank you.
Thank you very much. Let me just turn to the appellants to see if they are going to avail themselves of the 1 minute reply or cede that away. And I'm not sure which of you will speak to it. Mr. Reeves or Ms. Rauser?
No, thank you.
All right. Well, with that, no, thank you. And I'm going to be in the hands of our fearless organizers to move us in a moment into a breakout room where we'll have a chance to deliberate. But let me just say, until we come back with some more feedback, how on behalf of the panel, I think I can speak, how impressed we are with how you handled an unusually hot bench with waiting just seconds to dive in to what's such a compelling case and so many intriguing questions, and really wonderful to see all that terrific advocacy in action. But we'll have more feedback shortly, and I'm looking to Jen or the organizers to see how we will seamlessly move now into our deliberations.
Absolutely.